More likely than not, that 0.01% is all it takes to tip the scales of justice. Join us as Inner Circle legend Charla Aldous, Eleanor Aldous, and Caleb Miller walk you through the critical moments, big decisions, and bold strategies that win high-stakes cases and show you how to turn that 0.01% into a game-changing verdict. You're listening to the podcast where winning is more likely than not. Produced and powered by LawPods.
Hi there. Welcome to episode 6 of More Likely Than Not. Today, we're going to talk about using big data to control the courtroom and settlement environment. And we have one of the pros here with us from Las Vegas named Sean Claggett. And Sean has gone across the country teaching lawyers about how to try lawsuits, talking about big data, just amazing cutting edge type of things. And I don't know you very well, Sean, but there's 2 things I've heard about you. One is that you're a really humble guy despite your success, and that you love teaching and helping other lawyers.
Both true.
And those are 2 qualities that I think are outstanding, and sometimes we don't have a lot of those qualities in our profession. Would you agree?
Yeah, I think so. I think the personal injury world is designed to maybe live a little higher and brag about yourself a little more than would be normal.
What I always try to do in my practice is always remember it's not about me. It's about the client. It's always about the client.
It makes it easier when you understand that.
It really does. And I've heard that that's what drives you. And so I'm thrilled to have you on our podcast here today. First of all, tell us a little bit about yourself. You're from Las Vegas?
I'm from Las Vegas, originally born in Twin Falls, Idaho. I moved to Las Vegas when I was 10 in the 4th grade and hated it. And I'm the only brother left in Vegas now.
How many brothers did you have?
I'm the middle of 3. So
okay.
My older brother's in Tucson, my little brother's in just outside of Charlotte, North Carolina.
And since you hated it, I just got to ask you, why are you still there?
Well, because I learned to love it. It was, Vegas was a tough place to grow up, right? A lot of my friends didn't make it. I buried 14 of my friends.
Are you serious?
Yeah, a lot of my friends have passed away from drug use and car wrecks. And, it was a tough place from that standpoint. But I learned at a young age that, you got to have moderation in life. And if you can make it in Vegas, you can make it anywhere. I mean, it's a fast-paced life in Vegas, but Vegas also has a different part of Vegas that if you like being outdoors, which I do, has Mount Charleston, it has Red Rock Canyon, it has Colorado River, Lake Mead, all these beautiful places. And Red Rock Canyon to me is maybe the most beautiful place in the world. And it's right in my backyard. So I love hiking out there and spending time out there.
I don't know if this is true, but I heard a rumor, you can tell me if it's a rumor or not, that when you were young, you would get in fights quite a bit. And that you really didn't like bullies. Am I right about that?
Yeah, I love fighting.
Now you get to do it in the courtroom.
Yeah, well, no, I think now my body would not survive a fight all that well. That's why when you're young, you fight. When you're older, you use your wisdom to avoid fights.
Is it true that in 9th grade, you got accused of a crime that you did not commit?
That is true.
I got to hear this story.
Yeah, well, it's a reason why I'm a lawyer. In 9th grade, I was in a junior high, and we were in a passing period. I was with my friend Rachel and Justin, and in front of us was a couple other folks, a boy and a girl, and the boy and the girl got in an argument. The girl slapped the boy, and the boy pushed the girl onto the ground, and I went and helped the girl up, and I was like, geez, Ryan, dude, what the hell? You can't be pushing girls on the ground. He's like, yeah, she hit me in the face. I'm like, told the girl, you can't hit him in the face. That's not cool either. Those are both bad.
Yeah.
That was it. And it was sad because they were friends and they got in an argument and it wasn't good. And the next day I came to school and got arrested.
Are you kidding me?
Yeah, I got arrested, as did my friend Ryan. I had no idea what was going on. I was like literally dumbfounded. And so my mom, I'm sitting there in zip tie handcuffs. They searched my bag, my locker, and I have no idea what's going on. And my mom comes and ultimately meets with them, and they finally undo my handcuffs, which was awful because it was hours I was in those things. And my mom gets me, and mom's like, "You are sick." And I'm like, "Whoa, what did they say I did?" And she tells me, I'm like, "Mom, that is not true." And one of the girls who was a witness was my neighbor. and she was not there. And so we met with her mom and dad that night, and they said, she admitted, she goes, no, this girl's mom wrote the statements and we just signed them. We didn't know we'd get in this kind of trouble. So then Justin, the Mormon kid I was with, who's now a lawyer, he wrote an affidavit for me, and we gave that to the school, and the school said they never got it, so they did an ROC. He went to the Mormon church, and the lawyer there did it all. And so then my parents were like, we didn't have any money, right? So it's like, will you please let my son back into school? And I'm in 9th grade, and they're not letting me do my homework. They're giving me Fs on every assignment. So I was a straight A student, and my grades were plummeting, which was ruining any chance I had to go to college, or at least the colleges I'd want to go to. So ultimately, my mom gets a lawyer, and they were able to negotiate out a deal even after every witness had confirmed that it never happened. But the assistant principal was just pushing this, and ultimately I was allowed to go to a different high school. My brother was going to a high school. I was at a junior high, so I just ended up going to that high school. And 2 things are interesting about that. One is the vice principal who was doing all this was arrested shortly thereafter for child porn.
Oh my gosh.
Secondly, by being kicked out of school and made to go to this other school, the first class I had was an English class, and sitting in that class was this beautiful Filipino girl. And we've been together ever since.
Are you kidding?
Yeah, so she is my wife of 25 years and been dating for 33 years.
So it had a good ending to that story.
It had a good ending, and I became a lawyer, and things worked out. I had dinner with Joe Freed recently, and I had one of the most impactful conversations of my life with him. And he told me that, the universe is always working in my favor. And he tells me all about this. I'm like, that's interesting. He goes, yeah, even when really bad things happen, it's happening for a reason. And it's going to be so you can handle something in the future, some reason. And I said, I believe that too. I've never thought about it in those terms. And I look back at that moment, and it was a very dark time for me. It was a time where being kicked out of school, I started, I was out of school for months. This wasn't a week or two, this was months. And so I started hanging out with kids that did drugs and drank. And I started drinking and doing drugs, and I got myself into probably bad situations. But it was all stuff that was designed to work in my favor now.
I love that philosophy because it was a defining moment in your life that could have been absolutely disastrous, but it put you on the path to where you are today.
Yeah, and everything worked out. All that adversity, I use that every day of my life now.
Oh, absolutely. I firmly believe that. And Sean, I bet that's one reason you can relate to jury so well, is because you know people, you've been through pain, you know what it's like.
Yeah, I think that's right. I think if you look around to the best trial lawyers in the country, usually we all share some pretty horrible tragedies that have happened, and that we can tap into that internal pain that we all have there, and we know what that pain really feels and looks like. And when you're telling the story of your clients, I think that you can emote that pain because you feel it. You actually are sharing and feeling the pain of your client.
It's interesting you say that, because that's what I've always thought. If you've gone through some really, really tough times, then it gives you the ability to truly feel sometimes what your clients, or something similar to what your clients are feeling. But okay, let me ask you this. You decided to go to law school because your mother hired a lawyer and that lawyer helped you?
Yeah, well, pretty much. I didn't know that I wanted to be a lawyer, but after that event, I'm like, I'm going to be a lawyer because this isn't right what happened. I was getting railroaded, because I'm like, you're accused of something and there is nothing you can do how do you prove a negative? I'm like, I didn't do it. Well, that's hard to prove when people are saying you did it. And so I was like, and if we didn't have the lawyer, and my life would have been totally different, because I would have never got back into school.
So you went to law school. Tell us what your first job out of law school was.
So probably an interesting fact is I did really well in law school. First time I ever cared about school in my life. And so I did well. I was in the top 10 in my class. I did moot court. I was on law review, and I had the opportunity to go to big law. And I interviewed at the most prestigious firm in all of Las Vegas. And they asked me why I'd be a good fit there. And I walked in and I saw how stuffy it was. And I looked right at them like, I'm sorry I wasted your time.
I thought you were going to say you got an offer and you worked there. I cannot see you working in a big firm like that.
My poor wife, they were paying $8,000 a month. This a long time ago. It was a lot of money. And my wife's like, how'd it go? I'm like, yeah, I told it was not a good fit, babe. I can't do it. And so what I did is I ended up taking a job for $15 an hour with a criminal defense lawyer.
Now, that is a great story. I love it.
Yeah. And it's funny because when I went to law school, the first day, the intro to law week, they said, why do you want to be a lawyer? And all these people had these altruistic answers. And my answer was, I'm here to make a lot of money.
The honest answer, right?
Well, I thought, I didn't know. I mean, I was a banker. And I was like, well, I'm investing 3 years of time. I'm better make a lot of money. But then when I was offered a lot of money, I realized it wasn't the money. It was something else driving me. And so I ended up working for Michael Cristalli in a solo practitioner criminal defense setting, and as a law clerk for a year, and then 15 months as a lawyer, then started my own firm in January of 2005.
Wow. So you went right into starting your own firm earlier in your career.
Yeah.
That takes a lot of guts.
Well, I didn't have to make a lot of money to surpass what I was being paid. so the standard,
16
the bar
an
was
hour.
low.
There wasn't a lot of risk financially. I could accidentally make more than I was being paid.
I want to go back and I want to ask you one question.
Yeah.
Because I don't want to miss it. I've heard you talk about, starting your own firm, but out of all the podcasts you've done, I think you only mentioned your first trial on one of the podcast episodes I heard that was not a personal injury case. And I want you to tell the listeners about that because it's a really funny story.
Yeah. So I'm working for a criminal defense firm. I'm a first-year lawyer, and my boss decided to take a patent infringement case against 3M. Why? Well, because his brother-in-law was the distributor of the product in Vegas. So therefore we would take the case, right? So my boss had no clue about patent law, and he hands this case to me. And it's like, this is your responsibility. I didn't understand civil discovery. I didn't understand anything. So I put it together the best I can. I figure it out, and we go to trial, and I'm pretty certain we're going to lose because we don't know what we're doing. And so I go to the defense attorney named Ed Schwartz. I'll never forget his name, thick Boston accent. And he was 3M's guy. He's their trial lawyer. I offer $50,000, and Ed looks at me and says, go fuck yourself. And I'm like, is that your counteroffer, Ed? So my client's name was Paul Poirier. He was a French-Canadian who had invented this product. And he says, well, what'd they say? And I'm like, they told me to go fuck myself. And he's like, what does that mean? I'm like, it means we're going to go pick a jury. So we go on in and pick the jury. And my client had been countersued for defamation. So there was these emails that were at issue. And the judge was this it's federal court, which is
terrifying,
super intimidating. I mean, the judge was 37 feet above me, right, looking down. It was like, I don't even know what a sidebar is at this point in my career, right? But I'm asking my client questions, and I've got the original emails, and the defense was very nice. They made the exhibit binder for me. Wasn't that nice of them?
That is so thoughtful.
It was so thoughtful. And what they decided to do to make it better for me was they would manipulate all the evidence and alter the evidence by deleting and pasting emails to make it look like they say different things. So Paul's on the stand, and I'm asking him questions. I'm like, Paul, it's right here. And he's like, I don't see it. So I go and approach, and I look, and I'm like, Your Honor, can we have a sidebar? And I take the binders they made with the original exhibit, and I'm like, Your Honor, I go, they've manipulated the exhibits. Like, here's the actual emails, and here's what they put in the binders. And the judge, I'm a puppy lawyer, and the judge looking at this defense attorney is very experienced, and he says, we're going to take a break, and you're going to figure this out. And so I'm like, all right. And so Ed's like, well, let's just go ahead, and we'll just reinsert yours and mine. I'm like, go fuck yourself. And he's like, what? I'm like, weren't those your words to me before trial started? Think they were. And I'm like, I don't think what you did is right. I want to talk to the judge about this. This is terrible, I think. I'm pretty sure.
Blatantly dishonest and unethical.
I didn't know what the rules, I didn't know anything. I've been a lawyer for like 6 months. And so the judge comes out, and Ed's like, Your Honor, he's not willing to work with me. And he goes, and I don't blame him.
The judge said that.
The judge said this. He goes, I am striking your counterclaim, and all these exhibits are out. And you do this, if one more thing like this happens, I'll strike your answer. So we go and we finish the trial and went on the merits. And at the end, the jury gave me $1.3 million and a finding of willful infringement, which was treble damages.
That is a great story.
Yeah. So that was
So the lawyer actually changed the exhibits and manipulated the evidence.
Mm-hmm.
Boy, that's a disappointment, isn't it?
Well, you want to talk about a lesson learned?
Yeah, I guess that's true.
I've never allowed anybody to make a trial binder ever again. We make our own, period.
That's a tough lesson to learn when you can't trust an officer of the court like that. It's
Well,
very disappointing.
The nice thing is the judge, I've never had another good experience in federal court. That was the first and only time, I think. But what a great judge to be there, to be, appropriately angry with an older attorney taking advantage of a younger lawyer.
So that was your first trial, and then how did you get into personal injury? Did you start out doing that when you started your firm?
No, I had no intent to do personal injury. When I started my firm, I was doing criminal defense, credit repair, some bankruptcy, some family law, just kind of general practice. I took one personal injury case. It was a rear ender, and I tried it. I wasn't scared of trial, because I did enough criminal defense where I wasn't worried about trial. But I went and lost a rear end wreck, my first personal injury case. I'm like, well, personal injury is dumb. And so I didn't do personal injury again. I didn't try another personal injury case for almost 10 years.
Wow.
And really, it was happenstance that the economy collapsed in 08, 9, and 10 that I had to focus in on doing personal injury because I didn't know how else to make money. And so it was because of the economy that I started doing personal injury and then really went all in. And we were talking earlier, but Dorothy Clay Sims was presenting, and I watched. That was the first time I.
Tell our listeners who Dorothy Clay Sims is.
Oh my gosh, Dorothy Clay Sims! If you don't know her, you need to go and watch her speak. Get her book on deposing deceptive doctors. It is a must-have in your library because it teaches you all about the medicine and good questions to ask in depots. And Dorothy, there's not a more important person, I think, in our field when it comes to medicine and deposing doctors than Dorothy Clay Sims. And she shares her information in the most giving way I've ever seen. She is an unbelievable, wonderful human being. And she's become a dear friend. But at the moment that I saw her speak, it changed my entire course of my career because of the way she spoke and the way she taught how you can go at these doctors. I was fascinated by that. I want to go after you. If you're lying, I want to expose the lie. And she gave me a roadmap to do that. And then she said to read 2 books, which was Rules of the Road by Rick Friedman and Malone and The Reptile by Keenan and Ball. And I read them both. And the rest, kind of is history. I just went all in on learning everything I could.
About personal injury work.
Yeah.
That's really neat. Did you watch any of the CVN trial recordings or anything of that nature? Courtroom View Network.
Oh, yeah. I'm an avid watcher of it now. I started watching those in 2015, which was kind of, I don't know how early on that was. I think there was earlier ones, but that's when I was introduced to it, and I started watching some of the greats around the country try cases, and I picked up on a lot doing that.
I'm still a trial junkie after 40 years. If there's a trial, an interesting case going on in Dallas County, I'll go down there and watch it, and inevitably I learn something every single time.
It's fun, and the problem is when you do that, you get the itch, and you're like, you need to go back. You need to find a case to go try.
Isn't it the truth? It is the itch is the great way to describe it.
Yeah, I get it bad. I've got it bad right now. I'm itching.
Do you ever go back and think about that first personal injury trial you lost and think, based on what you know now, what you would have done different?
Well, understand that I was used to criminal defense where you get one closing.
Okay.
When the judge looked at me and goes, Mr. Claggett, rebuttal? I'm like,
do what?
What is that?
Come again? Wait, I got to go again? I was so unfamiliar territory. I did everything possibly wrong you could, I think. I mean, that's how do you lose a rear end wreck where your client did nothing wrong and clearly was hurt?
I lost, it wasn't the first case I tried. The first case I tried, I got spoiled because I think I was the second chair, and it was like 3 months after I'd been licensed. And I had a friend who was like, hey, you want to come try a case with me? I said, yeah, I'll do it. We went, we tried a case. It was a car wreck case. And the jury came back, and the question was, can we award more than they asked for? And I said, this is easy. And so won that case. And the second one was a rear end collision. I was solo, and I lost that case. and there, you look back and you realize there were so many easy ways I should have won that case, that you learn later. But that one, to this day, I'll think back, man, if I would have just done 1 or 2 things differently, I would have won.
I will tell you that there was a case I tried, a DUI case. They paid us policy limits, but we should have blown it wide open, So it was a loss, in my opinion. And the attorney who did the case was a good guy, still a friend. But I was like, dude, the second I get a chance to do another case against him, I'm going to destroy him, and I did. And we got a $14.1 million verdict against him. He quit the practice of law the Thursday before trial ended. He was a named partner in his firm. He went and cleaned his office out and says, I'm done. I don't want to do this anymore.
Not a good way to go out.
Well, it was the adjuster was telling him to do things that he didn't believe in. He's such a good human being, but the adjusters were just so aggressive. He's like, I don't want to do this anymore. I want to be able to try a case the way I want to try it. But he literally quit.
That is a great
mid-trial.
Mid-trial. He comes and tells me, he's like, dude, I cleared my office out. I quit.
I'm done.
Notice. I'm like, bro, the trial's not done yet. So if you watch that on CVN, it's the JuryBall v. Shack LLC case. If you watch his closing, you can tell.
His heart wasn't in it.
Oh, he literally was like, yeah, whatever. I think those were his final words.
Just get me through this. Get me out of here.
Whatever.
You are nationally known, Sean, literally to be one of the best trial lawyers we have in our country. And I've always heard that you are really big on focus groups. Tell us about that. How do you focus group your cases and how frequently do you do that?
Yeah, so I started out learning how to do focus groups back in 2010. And I started doing what we called focus group Fridays at my office. Every Friday, because Fridays were typically slow. Things aren't really happening on Fridays in the court. All the judges want to take the day off or what have you. And so things are slower. And so we had focus group Fridays. And we would do 52 focus groups a year at my firm. And
52 a year?
Yeah, we do one every Friday.
Wow.
Every Friday. I was asked to teach focus groups. And I'm like, well, I've only done like 2 focus groups. I'm being asked to teach. That ain't right. So by the time I taught, I'd done 14. And then the next time I taught, I'd done like 40. And then the next time I taught, I'd done like 70.
So when you have Focus Group Friday, tell us, what does that mean? How do you get the people in the office that are going to be a part of the focus group? What is the process?
So we originally were doing it in the firm. And my paralegals who were doing the work were just like, Sean, can we be honest with you? This is way too much work. We can't do this and get our work done. And I said, oh, okay. So we end up hiring a full-time recruiter, and all this person does is recruit every day. They're just constantly getting people into the queue so that when we want to do a focus group, we can say we want all conservatives, we want all liberals, we want a mix, we want men, we want women, we want whatever. We have about 3,000 people at all time in the queue that we can just draw from.
Wow.
And so, yeah, so it's a full business model. It's called Paramount Focus Groups. We literally set up a whole different company. It's not a huge profit maker. I don't think if somebody's listening to this going, oh, then I can make a lot of money. I'm like, I don't think so. But it's a lost leader, because what we do is we invite other lawyers in the community to come in, and if we have 4 hours, we only need 2. We could be like, hey, if anybody's interested, like your Dallas Trial Lawyers, what a great organization. You could be on that listserv and be like, hey, we've got 2 hours if anybody wants to come over and use an hour or 2 for one of their cases. It's a great way to create the community of people focus grouping.
That is fascinating. What is the name of the company again?
Paramount Focus Groups.
So if anybody wanted to look it up, do they just go to ParamountFocusGroup.com?
Yeah, they can do that. And we do focus groups around the country. Alex Gonzalez is the guy he's my nephew, but he runs that company very well. And he goes around, he probably does 150 focus groups a year, with the company. And probably about 30 of those are outside of Vegas.
That sounds really, really interesting.
Yeah, it's fun.
I'm going to definitely look it up.
Yeah, it's something that I would recommend. I mean, look, you don't get enough reps as a trial lawyer anymore to be proficient in front of a jury. You're going to be rusty. And so if you're doing live focus groups regularly, I still do them. If I'm going to have a trial, I'll go do 3 or 4 focus groups the week before trial, just so that I'm getting my reps, because I want to be comfortable when I walk in. Everybody's like, oh, you've done so many trials. I'm like, yeah, but I don't care how many you've done. If you haven't done a rep of voir dire, you're going to be a little bit off.
You get rusty. You really do.
And it happens quick, I feel. I feel like if I take off more than 3 months from a trial, I feel like I'm not quite where I want to be. That's when I start doing the live focus groups.
We've had this discussion before, actually, in a previous episode. You look at some of the inner circle greats like Charla, and they have 200, 300, 400 jury trials. And as a young lawyer, I look at that, that just seems like it's impossible these days. And so you have to adapt. You can't go take 100 car wreck cases on and hope that, 20 of those goes to trial. There's no way you can work those cases up. And so I'm glad you brought up the focus group thing, because that was something I think we talked about in a previous episode, because Eleanor, an associate, well, everybody who listens would know, an associate at our firm, she just tried a case, and the attorney she tried it with, they did 4 or 5 focus groups, the same thing you're saying. And it was a thought I never had before that, I mean, if you're doing your opening in front of 10 to 12 people, 3 or 4 times, I mean, that's got to be basically the same thing as being in front of a jury.
The crazy thing is it will feel exactly the same thing as being in front of the jury, because it is the same thing. You're going to execute it. And, the important thing, too, is you may have parts of your opening that aren't hitting. Wouldn't it be nice to know ahead of time, like, hey, this doesn't make any sense. Oh, okay, we can just make that little, when you're doing the focus groups right before trial, you're making little tweaks, not big tweaks. If you're doing big tweaks right before trial, something went wrong.
Exactly.
But I'm talking about like, hey, this just wasn't really clear. Maybe you could put this in front of that and it'd make more sense.
But are you all doing stuff? I think Satch does it this way, where he's testing like deposition strategy with focus groups. He's doing like crosses and things like that early on in a case. Are y'all doing it that way? Or are you waiting till, you've run your big data study, what the issues are, you just want to kind of test some of the strategies for trial?
No, we will have done live focus groups. Typically, when we first take a case in, we'll run a live focus group on it just to make sure there's nothing wacky that we're not seeing. And it also, I encourage everybody, we have a lot of lawyers, so there's a lot of attorneys getting their reps in. That's just why we're doing so many focus groups. But I encourage attorneys to do that all the time. So I don't do depots the way Satch does them. He's as advanced as you get probably in depo. We do love his book, so anybody that's listening, Deposition is Trial is a great book, and I had the luxury of reading that book before it came out, and I made sure that every one of my lawyers has read it. So it's got a lot of good practical tips in it.
Yeah, we had him out here, kind of like we did for you. You get a twofer, right? Which is, I didn't tell Sean until he came out to do our DTLA CLE that, hey, you're going to be around. You want to stick around and do a podcast?
Yeah.
Satch didn't do a podcast with us, but he stuck around afterwards, and he told our members about his deposition strategy. And I couldn't believe at that time that there were so many good lawyers doing multiple focus groups on every case before they go to trial. Like, I had heard of people doing focus groups, but I just assumed you're doing that in lieu of a big data study, not in conjunction with a big data study.
I think you got to do both. The big data is awesome. And if you're a good trial lawyer and you get big data, you're going to be able to put together one hell of a story that's going to hit. But the live focus groups is just it's a different skill set.
The next thing I was going to ask you about is big data. Some people don't even know what big data is. Tell us how you got involved in all of that.
Yeah, so probably in 2015-ish, there was a company called Jury Analyst that had popped up, and it was Robert Eaglet actually was the one who started that company.
Okay.
And he had an interesting promotion where he dropped a bunch of stuff at a conference down from a drone, and I picked it up, and it was a free jury analyst something or another, and I'm like, well, what is this? And I had been doing live focus groups, and I had a particular case that I tried in 2016 where I had done 17 focus groups, I think.
On that one case?
On one case.
Goodness.
And my older brother had created a software for me to gather data from live focus groups so that I could, because I was seeing patterns, and I'm a math guy, so like when I see patterns in behavior, I'm like, okay, that's not random. There's a reason why you're seeing it over and over again. Something's hitting. So I had the software, and I'm like, oh, what they're doing makes a lot of sense. So I was using them and was fascinated by it. And then I was reading, I was a professor, adjunct professor at UNLV Boyd School of Law, and of course I'm reading peer-reviewed stuff on jury behavior, and John Campbell was publishing stuff out of University of Denver at the time that was really cutting edge. And I go, man, this guy's got some cool stuff going on. And so then I had heard that he was doing big data, so I reached out to him. He's like, yeah, I am. I'm like, well, let's talk about this. And so John ended up saying, hey, I'm going to be out in Vegas. How about we grab dinner? I'm like, all right, yeah. I go, but I got focus groups all day. He goes, oh, so do I. No big deal. Let's just grab dinner when we're done. I'm like, all right, cool. Well, unbeknownst to me or John, we were both asked by Alex Alvarez and Bob Kelly, 2 great lawyers out of Florida, to observe their focus groups because they were seeing if tobacco cases in Nevada would work. And so we both went and met each other in person for the first time.
You and John Campbell were both asked. Isn't that interesting?
And John and I became best of friends, and Alicia and my wife Lou, and we're all super, super tight now and consider them family.
You know, I don't remember how I met John Campbell, but I've racked my brain. He might remember it, but I've been using him in the big data studies for years now. And tell our listeners what a big data study is.
Yeah, so a big data study is the idea of, instead of like 10 people live in a focus group, we're going to take 250, 350, however big number, more than 250, I would say, but do it online and present them with a plaintiff statement and a defense statement. And that may include video deposition clips, demonstratives, key exhibits. You basically put on the whole story for both sides. And then you ask a series of questions that the data scientists that are much smarter than you and I, we were talking about not really understanding how it works. But the data scientists put together a series of questions that are asked. And then we end up getting answers to questions. And then out comes this report that tells us what the win rate is, what the value, best number we should tell the jury the case is worth, and then a whole bunch of other information like what's driving the behavior of defense jurors, what's driving the behavior of plaintiff jurors, how much does it impact the verdict if X happens, how much if Y happens. And so you start to really get a lot of power as a storyteller to basically know what's going to move behavior and how much it's going to move it, and what words to use. All that stuff is what the big data study is.
And it's fascinating. It really is. I know the year before COVID, our firm, and we have a small firm, we tried 4 cases to a verdict. One we was doing pro bono. A young woman was raped by a football player, and I was just mad, so I sued him. Knew we would never get any money, but we didn't do it on that one. But with John, we did big data studies on all 3 of the cases. It was unbelievable how accurate it was. It was, came back on the amount of the verdict, the comparative negligence. He nailed it on every single one of those cases.
Yeah, the big advantage that you have working with John and Alicia is they're both trial lawyers.
Exactly.
Alicia and I had the benefit of trying the case a few months ago in Denver together.
Was that the insurance case?
Yeah.
John told me that y'all were going to trial, and I think you won it big.
We did. We got $145 million on that one.
That's big, Sean.
Yeah, that was a good one. That was a good result.
I feel like compared to some of the other ones recently, that's not that big for you.
It's been a crazy year with verdicts. We've done well, 3 in a row that have been pretty big.
So you and I were talking in the car on the way to the CLE earlier, and you were telling me that you think our firm was basically one of the first adapters of big data, which was news to me. I didn't know. So I guess what I'm kind of curious to hear, because I didn't track this, was what was the evolution of what y'all were doing and John was doing like 2016, 2017 versus where it's at now?
Oh, it's amazing. The evolution is now we have the benefit of so many people doing data studies that you can start to test different things on a more regular basis and get enough responses where you can have a certain level of certainty. Like the information we're testing right now, right? There's this hypothesis that the likability of the lawyers in opening, is that predictive of the outcome? Now that's not really helpful to anybody in prepping for a trial, but it's certainly fascinating on the back end to understand your behavior at trial. One of the things that I've had to work on, and I'm constantly working on it, is I have an Irish temper. And so I can get agitated at trial and maybe be too aggressive. That we believe can actually really hurt you. And we're trying to figure out how much and if that's true or not. And so these are different things that we're testing. And if you look at the early reports, the information you were getting versus the reports now, it's just way more detailed. You're getting way more information that we've learned over the 10 years that, hey, we need to look at this, we need to look at that. And so I would just say the overall knowledge base of John and his team, John and Alicia and their team, is so far advanced. It's kind of like if you look at electric cars, like there's a lot of electric cars, but Tesla has the advantage of self-driving, and they've got billions of miles head start on everybody else to get the data on that. And so I think that's where John and Alicia are. They're over 500,000 people have been studied.
That's interesting you say that, because what I noticed with John and Alicia is maybe 2-3 years ago when we started running more and more studies, what John would tell me is I'd be writing a script for a case we had coming up for trial or mediation. A case we had taken a bunch of depots on, we're basically ready to go try. And I would submit a script and he would say, hey, I've had like 5 other cases in the past that are very similar facts, I think what you need to do is you need to say X, Y, and Z, or you need to start with this fact. I think if you start that way, you're going to see an increase in the liability here. And it's like he can, at this point, I feel like he could already tell me what the results of my case are, and he doesn't even have to run the study.
Well, I mean, the big benefit is John and Alicia try cases. When you're writing your studies, I mean, they're just going to sit there and they really go through them. And it's impactful to have them look at your studies and tell you things like that. Routinely work with attorneys and they'll write a plaintiff statement that's robust and great, and then their defense statement is weak and shallow. We look at them like, hey, listen, if you want us to run the study this way, we can tell you great news. It's not the truth, but you can get great news in a study, because garbage in is garbage out. I always laugh because when the defense lawyers, when we're telling them what the data is showing, they're like, well, how do we know you didn't rig it? I'm like, you don't.
But there's that question at the end that they incorporate now into all the studies, which basically says, who do you think created this study, or who do you think's running the study, which is supposed to tell you if it's neutral or not.
Yeah, well, that's right. We know it's neutral.
Yeah.
But the defense, and I just tell them, I'm like, well, why don't you write the defense statement? And I've already written my statement. We'll go test them. I promise you I'll take the median or the mean. I'll take the average, either one. You tell me which one, or we can split the middle between those two. And they're like, well, but I'm like, no, I mean, it's fine. I go, or guess what? We call it FAFO at our office.
I'm scared to ask.
Yeah, I was
mean?
like, who's going to ask that?
Fuck around and find out. you can do it. You can do it. You want to be the next one? Because believe it or not, we're not scared to go to trial. It's all we do all the time. We're getting ready for in trial. Somewhere along that spectrum is all I do. And I'm like, I don't want to make you famous, but I will.
Yeah, you don't
or
want your
infamous is the case.
name in that article about the record-setting verdict.
Well, we just did a trial on Friday. You got that $205 million. The defense attorney in that case, I was just the jury consultant in this case, right? So I'm being nice. I'm on my best behavior. I'm being a lovely human
You're
being.
behaving yourself.
And she is so rude and mean to me and nasty, and it's like nonstop. And I'm like, after the second day, after we had the jury, I go, you've been really awful.
You said this to her?
Yeah, I go, you've been really just mean and nasty. And I'm like, I'm going to tell you what's going to happen. I'm going to go find a case that you're on, and I'm going to take it just to destroy you in a case. I want you to feel what it feels like to go up against me for real, not me as a jury consultant. I go, I'm going to make you pay for your behavior. And so
what was her response?
She was all like, she was just like flustered. And so we're half an hour later, we're leaving out of court, and she goes, can we reset? Can we just get a reset? I'm like, absolutely. I'd love a reset. She goes, okay, so you're not going to really pro hoc in. I'm like, oh, no, I'm totally going to. So the next, I sent out an email. I had my buddies in the Colorado trial lawyers send out an email asking anybody if they have a case against them. I had 5 responses, and I took the best case. And the next morning I came in and told her, I say, I'm going to see you real soon. I'm pro hocking in.
Did you really?
Huh?
And are you pro hocking in?
I am. I'm going to go and absolutely smoke them. And I told them on this case, I said, you're going to be famous on this case. You guys are going to take a 9-figure verdict.
Will you let me know when you try that case against her? I'm going to come watch.
I would imagine after this beat down that they're probably not in a hurry to try another case.
She may be withdrawing.
I got to tell you one funny John Campbell story. I got asked to help try a case in Orange County, California, and the night before we're starting trial, I'm looking at it. I'm like, I'm not feeling really good about this case. I have some questions about it. And I called John and I said, do you love me? And he goes, what do you want? And I said, I need a big data study. And he said, okay, when are you set for trial? I said, well, I'm in trial. He's like, you got to be kidding me, Charla. I said, but it's going to go for, several weeks, John, but I really need to know how aggressively I need to try to settle the case. And after 2 or 3 days, he called me and he goes, well, you're going to lose 11 out of 12 times. So get your settlement hat on right now. And we got a high-low in that case. And it was because of his big data study showing me, absolutely, you are most likely going to lose this case.
Yeah, look, I don't like risk. It's funny because we're in a risky business.
Right.
But with data, you go in eyes wide open. If you're taking a risk, you're going to be able to tell your client, listen, there's a real risk here. Sometimes you'd just be wrong. We'd have cases we think were losers that were winners. And we'd have cases that were losers that, we thought we were going to win.
That is a big, important point, too. It has given me some sense of solace when I know that I've got a client and I'm trying to evaluate the case, and I want to make sure that I'm not underselling and I'm not overpromising with a client. And to run a big data study and you get the numbers, and it gives me comfort to know, okay, I can give this client this advice, and it's on my gut, having tried all these cases, but it's also on the data that I get from those studies.
It also allows yourself to give yourself some grace.
Wow, is that not true?
There's times where you lose trials and you just beat yourself up nonstop, and you're like, and it's the worst feeling. Anybody that's tried and lost a case knows that feeling at night where you can't sleep and you're just second guessing everything you did in the case. We all know what we're talking about.
But you know what I've always said? If you have a lawyer that's never lost a case, you have a lawyer that hadn't tried many.
That's right. But, now it's like, okay, I know why I lost. We took a roll of the dice. We told the client. We advised them correctly. And, we had a 50-50 shot and we came up on the wrong side of it. It allows you to give yourself some more grace. Now, if you got a 90% winner and you lose it, that may...
That's not a lot of grace coming your way.
I do have a question, though. Something I think we were talking about. I was trying to get your opinion on earlier. That's something, since doing big data over the last 8 years, I've kind of retrained the way I think about cases. What percentage would you say of a case is the facts that you have in that case versus the attorney's skill as far as getting a big verdict or losing a case?
Oh, I think the facts matter a hell of a lot. I think that lawyers oftentimes take way more credit for the outcome than they should.
I totally agree.
I think that to be honest, we can look at the data. And I have the benefit of seeing a lot of lawyers who use data who are not, you meet them, you're like, they're not a talented trial lawyer. They're not, but they got a good case. And if they follow the facts and follow the data, they end up getting 8-figure verdicts. And they're not anybody that you'd be like, oh man, they're a great trial lawyer. Now, is there truth to a great trial lawyer getting better with data? Absolutely. I mean, it gives us an advantage that...
Oh, it's helped me. One area that it helped me, and it took John working with me a lot. I'm pretty bold, but sometimes when you're asking for 150 million, you kind of choke on it, like, So John started it, and I'm sure he does this in most of them. He'll do in the big data studies, if you ask for 100 million, what do they come back with? If you ask for 150, number one, are they offended? And number two, is the verdict higher? And it has been amazing, the results I've seen. And it's given me the confidence to know what I can go in and ask for and understand it's not going to put people off, but it's going to increase the amount of the verdict.
Yeah, I mean, that's right. And the confidence to tell the jury, we all know this is the right number. We all know it.
Right.
And when you can say that to them with conviction versus, I mean, I've seen lawyers go up there and we all know the case was like, what was it?
You're mumbling. Could you rephrase that?
We had a situation where an attorney told the jury a number in opening and then in closing changed the number lower.
Oh, no.
And they got defensed.
Yeah, because it makes it seem like they thought they did worse in trial or their case got worse.
Why did you just reduce the number by $17 million? Like, that's weird.
That is very, very strange.
I think the thing that's interesting about the big data and like the ask that we figured out, I would say the majority of time, there's not a number that's really too big we can ask for in our cases. Now, I have had one 2 years ago that told me that was wrong, that I was asking for too much. And we did get pushed back because the case wasn't great. And, it was more of a case you needed a liability finding more than the damages. But I think the thing that's hard for me and for some of us out there is, what are you taught when you get out of law school? You're taught you got to be reasonable. You can't offend a jury. And you're taught that a jury is going to think about a case the same way an adjuster thinks about a case or a defense lawyer thinks about a case. What are your past meds? What are your economic damages? We got to find a way to quantify this. But what we found from doing these studies is juries have no idea what a case is worth. And you're doing your client a disservice when you're going up there and you think you're being reasonable because you're undervaluing your cases.
Well, that's right. The scary thing is if you don't ask for enough money, you don't tell the jury the case has a certain value, they think you're hiding stuff from them. And they end up reducing the win rate to the point sometimes if you don't tell the jury the case has a certain value, you're too low, you get defensed. And if you ask for too much, you get defensed. And sometimes you're just having to, thread a needle with a certain amount of money. You need to know that. The crazy thing is when you look at the data and to just process, just getting the number wrong can impact your client by tens of millions of dollars. It's insane.
You know, another thing that I just thought about this, we tried a case last year and did the big data study, and how John will put at the end of the report comments that the different jurors made. And in this case, we had a comp bar of the employer, and it was a wrongful death case, and we were going after the parent company. And so many of those jurors, I can't remember how many, but a lot of them said, this sounds like a shell game. This sounds like a shell game. And I'm embarrassed to say I had not thought of that. And that became one of our themes in the case. And you just read through those comments and see what people are saying, and some of them different people saying the same thing. It can be really, really helpful.
Huge. And, that concept of a shell game, we consulted on a case up in Washington State with the great Eric Fong. He's a phenomenal trial lawyer. I don't know if your listeners know him or not, but he's one of the best. And he's just a touchy-feely, like totally different style, but it's so authentically him. And we had a case where he came to work with us doing a work day, and we were looking at the training materials, and I'm like, dude, it's a gas station. Why are there 4 different company names on the different training materials? Out of 2 days, we spent 1 full day trying to understand the organizational chart of a gas station, and that became the case.
Isn't that amazing?
It became the case because it was like nobody was actually trained, nobody really cared, but it's all about protecting assets, and it was crazy. And the verdict was $91 million.
There's something I want to say about that case Charla was just talking about. That was an example of a case where, first of all, I was wrong. I didn't think it was valued that high. I was buying into the defense arguments, I'll admit that. But the interesting thing about that case is, so we got our results back. It told us the case was worth 40, 50 million, something like that. And we had a really good win rate. But Charla's voir dire got just this amazing jury for a case that the data said we were going to win anyway. And I think that's an example of when you have the data, you know what you're supposed to do, and then you take a great trial lawyer who did one of the best voir dires I've ever seen and get this great jury, what can happen? And that's, we beat the data by $20 million or $25 million. For a $200 million case, that may not seem like a lot, but this was a $50 million case that we ended up getting, $70-something million verdict on. And I think when you combine those things, great trial skills with the data, the results can be amazing.
If you look at the data and you realize that to get to the 75th percentile means you're going to sit your best 25% jurors, that's where the great trial lawyering works. I mean, if you're really good at voir dire, you can take the data and get you can start moving it up pretty quick.
That's exactly what I did.
Yeah.
It was fascinating. It's really, there's no question in my mind, I have become a much better trial lawyer because of the big data studies and working with John Campbell.
And it makes it addictive.
It really does. I wish it didn't cost so much.
Yeah.
I just want to do it time and time and time again. I'm waiting on the right case where I'm going to bring John in as one of the lawyers,
We do contingency work with them pretty regularly, which is fun because the referring attorneys will bring them in.
And, they're just good people. I just like to be around them.
They're great
John
people.
Alicia.
And I'll tell you what's fascinating. The case that Alicia and I did in Denver in the spring, we were doing real-time data. So during the trial, we were running data studies after the witnesses.
I did not know that.
Oh, yeah. And we were seeing...
How fun.
We were seeing the impact of the testimony real-time. It was just shooting up. And I'm like, evidence was coming in so favorable. And the defense couldn't see it because they were procedurally crushing us. Excluding witnesses, limiting witnesses, excluding documents, just making and the judge was a good judge. We got in late in the case and we didn't follow any rules. We violated every one of and so she was punishing us, and rightfully so. I don't blame the judge. I actually think she's a good judge. I think she's a very good judge, actually. And so my team was frustrated, and it was frustrating to be part of something where, like, God, man, a lot of stuff's not happening. But the story we were telling
was getting through.
And we knew every day. It was so refreshing because as frustrated as we'd be, we get the data and like, dude, today was a good day. And it took the case, when we originally got the first data study we ran, there was a lot of problems with the case. We had to fix a lot of stuff in the 60 days that we had to fix it. The win rate was in the 50s and the value was about 30. By the time we got to trial, the win rate was in the 80s and the value was in the high 8 figures. By the time we were done with the first week of trial, the value was over 115.
Goodness gracious. What was the verdict?
145.
Jeez.
I remember I was talking to John. He said, "Well, Alicia's trying a case with Sean in I think it was Denver.
Yeah, it was
wasn't
Denver. Yeah.
Denver." And I said, "What kind of case?" He said, "Oh, it's boring. It's an insurance case." And I read about the verdict, and I said, "Hey, John, I just read about this boring insurance case, and it's a record-setting verdict. It was amazing."
Yeah, well, what's interesting is that the great thing about not knowing what the records are, you don't know when you're going to ask for a number that's going to shatter it.
Yeah, exactly.
And so we broke the record apparently in Denver, and so then I'm working with my good friend Dan Kaplis on this case that we just got a verdict on Friday that's also in Colorado. And we're doing the workup, and the data's coming back. I'm like, you need to get this verdict, because it's going to show that the 145 we got is not a crazy number. And I go, you should have the new record when this verdict's done, because you should get 165 million. And then he went out and ripped a $205 million verdict, which is just great, right? Because it's showing that none of these verdicts are they're
not outliers.
In both cases, the insurance company could have settled the cases for exponentially less money, but they chose to play games in FAFO.
I love that FAFO. That is really good. I'm glad I know what it means now.
Yeah.
You know, I always tell people, they say, "How do you get some of the big verdicts you've gotten?" I said, "Well, you can't fall out of the basement. When they don't offer you anything, you go try the case." And a lot of times, bad decisions on the side of the defense are what make for big verdicts.
I look back to every one of my big verdicts. There was terrible decisions made.
Right.
A lot of them, and they can't get out of their own way.
You know, it's reassuring, too, because when you're going into a trial and you know that they have not given you a fair offer, for me, my conscience is clear. I'm like, okay, let's go. It's time to tee it up.
Yeah, and, you know, the other thing, too, is I don't know if you feel this way, but I feel like I'm getting gaslit. I'm getting ready for these trials. I'm like, what am I missing?
What am I missing? I know.
How can they be looking at this case and be where they are? And we're looking at it, and we're...
Total different universe.
We think this is one of the great cases we're ever going to try. And they're offering me $750,000. And the data gives me solace in that, because it's like the defense just doesn't know the case.
Right.
And then you go try the case and you know what the defense best position is, and they don't even go there. That's the best part about it. I tried a case. There's one time I'm like, dude, we got a real problem if they go here, because it was an issue of a union worker driving a commercial vehicle that should have been fired, was fired, and then the union got him his job back. And I'm like, well, if they go and argue about the union can't be on the verdict form. There's nothing we can do about this. I mean, we had our response, which was they should have rehired him and not have him be a driver, was going to be our response. Right. But still, it was a problem. They
never brought it up?
Never touched it.
I love it. That's
I'm like,
so great.
Thank God.
The thing we have here, though, in Texas, and I think you and I were talking about that earlier, is like, we'll go mediate a case. We'll talk to the mediator and kind of do the thing. What are we missing here? We have our studies. Our studies show the case is worth X. We have the depositions where the corporate rep, said, this was their fault or whatever it is. What are we missing here? Why are they offering us $1 million when we know the case is worth 15? And now what we have in Texas is a lot of these folks are saying, well, we know we're going to get a big verdict. We're just going to appeal it. And that's such a frustrating position to be in. We can't do anything else other than go try the case.
Well, that and bond together, and raise money to take away the judges who don't believe in the Seventh Amendment.
It's exactly right.
Nick Rowley and I have an organization called Justice Watch it's a national organization that we raise money, and we go in and we get involved in in key judicial races around the country to unseat bad judges who don't believe in the Seventh Amendment. This is a national effort that all plaintiff lawyers need to get behind, and we need to we need to be raising tens of millions of dollars to be in these fights, because what we've seen is that state by state, we all fight alone.
Yeah. And that is so true.
And we get our asses kicked state by state. And what we know is if we fight together and raise money together, real money, I'm not talking fake money, I'm talking real money here, but we can go in and alter the outcome of these Supreme Court races. If you saw what happened in Montana, we flipped a seat in Montana in 2024. And then the critical race, my dear friend Al Folkler up in Wisconsin invited me to go speak to the Wisconsin trial lawyers, and I was introduced to the biggest Supreme Court race in the country. And at the time, it was a coin toss. So Nick and I got involved in that race. I think we got a lucky break that Elon Musk was very unlikable in the first 3 months of Trump's term. But that race ended up going to the progressive as opposed to the Trump-endorsed candidate. And it was a big deal. But, we can't sit here, you look at what goes on in Texas. People ask me, like, why don't you litigate in Texas? I'm like, because I don't want to have my verdicts taken. I don't see any appeal in that. It's not something that I'm lining up to do. But the judges that take away verdicts, that don't believe in the Seventh Amendment, that believe in socialism, right? Because these big verdicts are taken away. These people are hurt. You're going to have the taxpayer pay all the consequence as opposed to these for-profit corporations. So as long as you want to admit that you're a socialist and you believe in socialism on risk, but capitalism for profit, admit who you are.
I have never heard that before, Sean. I really like that.
Well,
so true.
I'm a Republican, and I have a great relationship.
You really are a Republican?
I am. I've always been a Republican because that's what my dad told me I was when I was a kid, and that's how I registered when I was 18. I've never changed. I have great dialogue with my Republican colleagues in Nevada, and I'm very close to the Republican governor. He's a wonderful governor in Nevada. He signed med-mal reform for us, a Republican. Our Democrat governor vowed to veto it. So our issues are not party-based. The Seventh Amendment is not
Absolutely.
a Democratic or Republican.
It should not be.
If you're going to support tort reform, then just admit you're a socialist. Just admit it. Say it out loud. Say it proudly that you're a socialist. And if you don't want to be a socialist, then stop supporting the crap laws that you're going to cause the taxpayer to pay for the hurt people.
That's a really good angle. I have never, ever thought of it that way.
Yeah, I mean, it's the truth, though, right? I mean, it's a
truth usually sounds pretty good.
It does sound good, and for the Republican, that they understand that, they really do, and you start to see there are some really good Republican politicians out there that support us, and so
absolutely,
we've done a great job in Nevada. We learned the hard way back in 2015 that our Nevada Justice Association, or political arm of that, was very left leaning, and we got smoked. And the tort reform that came out of that was, I mean, they were going to gut our product liability. I mean, all kinds of bad stuff. And thank goodness we had a Republican governor who vetoed it all.
We had a big fight on tort reform this last legislative session, and the Republicans are the ones that helped us defeat it.
Yeah.
I mean, they really did. Okay, let's move on from politics. And I want to ask you something about JuryBall.
Yeah.
What is JuryBall?
So JuryBall is a book that John, Alicia, and I wrote. It's actually a book that took a long time to write. We were working on it for years, and John Campbell came up with the name, and of course it's a play on Moneyball.
Right.
And I flew out to Spain, where they live, and we began writing the book and had it in large part written and edited. And we waited because we had this trial coming up in New Mexico, and we had run a bunch of different studies testing higher values. And we didn't want to publish the book without this verdict, because we were pretty certain the verdict was predicted at $511 million.
Wow.
And the first time we ran the study, we ran it up to $135 million, telling the jury the case was worth $135 max. We got no pushback. So then we tested it to $500 million, no pushback. Then we tested up to $1.1 billion and started to see a little push. And so we decided we would tell the jury the case was a $100 million compensatory with $1 billion in punitives. The jury came back at $485 million. So we took that case and edited the whole book by adding that in to talk about the studies. We felt very confident we would get a big verdict. But once we got the big verdict, like, okay, now everything that we thought that we wanted to put in, we can put in.
We know it's truth. That's wonderful.
And so we end up publishing the book.
It's a great book.
In June of 2024, right? We're in 2025
It was
now.
like right before TLU in October. It was like,
Yeah.
I remember the book had just come out like right before that seminar.
Yeah. So I think we released it in May or June of 24. Then we had our first conference in Madrid in April of this year, and we're having our North American conference in Las Vegas next week. We have the 29th, we're having folks over to my house for dinner, and then on the 30th of September, we're doing golf in the morning and a welcome reception, and then 1st and the 2nd, Four Seasons Las Vegas, we're doing a conference.
That is really exciting. And I love it because it's helping so many lawyers across the country be better lawyers.
It's really exciting. We have 225 people registered, which blows my mind that we have that many people that are that interested to come and learn. It is a little bit different. Like, the one thing about conferences, these 8-hour days kill me.
I'm with you.
So we're doing 5-hour days.
Oh, I love that.
So just come in, high level learning, and go have fun. And start a little bit later, end earlier. And we did that in Madrid. John and Alicia introduced everybody to the Spanish lifestyle there.
He wanted me to come over and speak at that, and I couldn't. I can't remember.
You
I
gotta
had a
come.
conflict.
You gotta come to. Have you ever been to
I've
Madrid?
been to Madrid, yeah.
Oh, it's the best.
But John and Alicia both told me, you got to come over and we're going to show it to you. We'll show you a different side.
Yeah, that was the best conference I've ever been to in my life. And I'm not saying it because it was JuryBall, but it was just so special because we were on a different time zone. And so while we were in the conference, nobody was working. Nobody had a distraction.
I had not even thought about that. Not on their iPads, not on their iPads.
Everybody was present. And it was really special.
That's cool.
And then John and Alicia, of course, had a person there cutting jamon and telling us all about the different types and what it means. And then we had the flamenco dancers. We had Spanish wine tasting, all these cool local flair things.
Right.
We're going to do it in Vegas style. We have some really...
we're going to learn all the local figures.
John and Alicia don't know all the special stuff we have planned. I didn't get to know everything about one in Madrid. So, they're totally responsible for Madrid. I'm totally responsible for Vegas.
That's fun.
So Vegas style is going to be Vegas style.
So for people who don't know what sort of things y'all will do at the conference, is like, why would somebody need to come there? Is it just big data, or what else are you teaching?
Yeah, no, it is. We are focused on the data. Unlike most legal conferences, we have Cornell professors coming to talk about their cutting edge stuff they're working on and the peer reviewed literature that they're working on. I'm really excited about this panel we're going to have. We have several jury consultants, Jessica Brylo, Harry Plotkin. Harry's bringing David D. Robertus, and Jessica Brylo has her attorney she's bringing, and then I'm bringing Dan Kaplis. And so we're going to have a panel discussion on jury consulting and big data and how the jury consultants are using it, along with the lawyers.
I wish I could attend that.
So it's like, this is different stuff, right? You just don't hear these type of topics at other conferences, and we're not trying to compete with other conferences. I mean, the nice thing about doing JuryBall is 100% of the proceeds that we make from the book and from the conference just go to support the JEDI organization, which is where we're funding peer-reviewed literature that's supporting Seventh Amendment and jury selection and voir dire, full voir dire, and they're publishing on this stuff. And then we're using the peer-reviewed publications in our motions to get better jury selection.
It's going to be such a benefit to our profession. Thank you. Thank you for doing that. I know it takes a lot of time.
It does take a lot of time, but it's, people are like, I don't know, how do you always do all this? But it's fun to me.
You love it.
Yeah, this is like, what else am I going to do? I love it.
So one thing you said that I've heard you say before that I want you to say on here too is, at a certain point, it will be malpractice for lawyers not to use big data. Explain what you mean by that.
Well, I've said this about focus groups. In 2010, I said, it's not the time right now. We're not doing focus groups to do malpractice, but it will be. Today, if you're not doing live focus groups before you do your trials, I think you are committing malpractice. I think that falls below the standard of care for a trial lawyer to go to trial and not having focus groups your case ever. I think that's malpractice. I think that's reckless. Big data, it's cutting edge today, although we've been doing it for a decade, right? I mean, it's not cutting edge to a lot of lawyers. It's something that's part of our toolkit. In 10 years from now, it's going to be malpractice because the defense is going to be doing it.
Right.
The defense is still ass backwards with their focus groups. Trial I did in Denver, they did focus groups. They spent like $100,000 doing a focus group with 80 people and doing clopenings, and they did all this work. And then they didn't ask any of the focus groups what the value of the case was. They were losing the case and getting hit for punitives, but didn't want to know how much. Dumb, but whatever. The problem is that they spent $100,000. They're going to start doing big data because they can do big data for 35.
Yeah.
Right.
I mean, and they're going to do it. And then if they're getting the information and you don't have it, can you imagine the shoe being on the foot, the defense lawyer having big data and you don't?
Scary.
Oh my gosh. You're smoked. You're smoked because they're going to be laser focused and you're not going to know what to do. The great thing is if you know what they're going to do and they know what to do, you can win because you go first.
I mean, you said today, you brought up a case example about comparative fault, and depending on, what state you practice in. Here in Texas, if the plaintiff is over 50% liable, they don't recover.
Mm-hmm.
And you can imagine a situation if a defendant had a big data study that says, here's how to put more than 50% on the plaintiff. And then you have a plaintiff lawyer who goes up there when they should be accepting some contrib, maybe a 10, 20%, because they know that the study will show that that'll help them. And instead they go up there and they say they did nothing wrong. I mean, it's the opposite of what you taught us today. on the other side. So that's dangerous. The one thing I've heard people say to justify the reason they don't want to know the value for defense is that if they put the exposure level or know that, there's a focus group that says the case is worth 50 million and they offer 10, now is that bad faith? And they've kind of created a file that goes against them. And so that's the explanation I've heard from my defense lawyer friends is some of these adjusters don't want a value to be in the file.
That's exactly why they do it. I mean, there's no logical reason. It's not logical. I mean, your job is to, as a adjuster, your job is to mitigate risk.
Exactly.
By not knowing what the risk is, how do you mitigate it?
All right, just a couple quick questions before we end that I think listeners might want to know. I just wrote down a few when you were talking. The first one I want to know is, do you tell the jury what the case is worth in opening? And if so, is there data to support that we should be doing that in our cases?
Having the benefit of trying cases in a lot of different jurisdictions, sometimes you're not allowed to. Sometimes you are. I talk about the value in voir dire as early and often as possible because I know that I want it out there. I oftentimes will tell them in opening what the value is. The more I can talk about the number, I want to talk about the number because I've already studied the case. I know how the evidence is going to come in. I know what's going to happen, and I know that the jury needs to be aware of what my number will be and understanding why they need to go there. I would encourage it, but some cases I don't have the opportunity to tell them what the number is in opening, and I got to wait till closing. But they at least hear it in voir dire. What's really hard is, if you go to like some jurisdictions,
They don't even let you talk about
in
money.
West Virginia, you can't even tell them a number.
I know.
Ever.
We got, even in Texas here, I think some, depending on the judges, Charla will always ask this question voir dire, for cause reasons, but for other reasons as well, to plant the idea of big numbers early on. But some judges don't let you talk about, is there anybody here who could never award an amount above $20 million despite the evidence or, what the court's instructions are? Some judges say you can't say a number at all. Some judges let you say millions, and then some judges say you can't say millions. And so depending on the judge here, we're dealing with the same situation.
This is why the peer-reviewed literature that JEDI is funding is so important, because we need more peer-reviewed literature to let the judges know that when they make those type of decisions, they're impacting the Seventh Amendment.
And so just a couple other questions here before we end. You have one firm philosophy that we were talking about before we started, the three of us, and that's that you really believe attorneys in your firm, or at least the partners in your firm, should be financially independent. And tell us why you think that.
I've preached to my firm and my partners the idea of being debt-free because, there's a great book called The Millionaire Next Door. If anybody wants to read a book on financial responsibility, it's a great book that everybody should read. It's been out for a long time. My mom made me read it back in the 90s.
I love that.
Yeah. Basically, the idea being is if you have no debt, you cannot be leveraged. And the insurance companies know when an attorney's behaving leveraged, and defense lawyers will know, like this guy, hey, he's out there, he's living this lifestyle, he's struggling, he keeps calling us about wanting to settle the case. We don't make those calls. We will not ask a defense firm to settle the case. They've got to call us.
Absolutely. That's what we do too.
Yeah. And so when they call us, I'll be like, well, I'm not real inclined to mediate with you because I've done that in the past and that doesn't work out too well. But if you want to agree to my parameters, fine. And we'll set out the parameters. And we send them a parameter letter. But fiscal responsibility as a lawyer creates freedom to do the right thing. You've heard that, the old adage, fuck you money.
Yeah.
What that really means is just that you have financial freedom to tell somebody, go screw off. I'm not going to settle this case. That's what you need to have as a trial lawyer. You need to have financial freedom to do the right thing. If you are in a position where you need money and you're going to go settle a case for the wrong number because you need money, you need to look yourself in the mirror real closely and see if this is, the right thing for you to be doing.
Kind of off that question, just something that I think we've talked about here at the firm a lot, that's kind of a moral dilemma for us, is what do you do when you have a big data study and the data says maybe your case is worth $100 million, but the other side's never going to pay that number and your clients desperately need the money and you have a really strong offer on the table? Say, if you have a $100 million case and maybe there's $40 million on the table and your client's saying, this is life-changing money. I need this. I can't wait 3-4 years. What do you do in that situation?
You settle the case every time.
Absolutely. And it's hard. It really is. We had that recently where we settled a case pre-suit, and it was not worth what the case would have been worth, with a jury verdict. But we had a quadriplegic client. They were desperate for money. It was more money than they ever needed. We had to sit down and talk and say, there's no question, we've got to do this. It's the right thing for the client.
There's a saying that verdicts feed egos.
Settlements feed families.
Settlements feed families, and that there's truth to that. And you have to put your ego aside on some of these. And, we have a case right now. I had a partner that was in mediation yesterday. The client gave a directive that they wanted to be done. And it sucked because I'm like, the way the defense was behaving during mediation, they deserve to be
punished,
curb stomped.
Yeah.
But the client, some clients have lower tolerance. And so the clients are always the one getting to make the decision, and you got to respect it. And like you said, you get these huge offers. It takes a special person to say no.
I think the hard thing is, you surround yourself with other attorneys that tout these massive verdicts. I got $100 million for this kind of trucking case and, this much for this kind of case. And so sometimes when you're in this situation, you say, well, I think the hard thing is, you surround yourself with other attorneys that tout these massive verdicts. I got $100 million for this kind of trucking case and, this much for this kind of case. And so sometimes when you're in this situation, you say, well, I want to serve my client. I want to do what's best, but you have everybody else telling you need to file that case. You need to go try it. You need to get a 9-figure verdict. And the balance sometimes is difficult when you have, people telling you different things. And I think it's one of the reasons I respect Charla so much is since I started here 8 years ago, not once has it ever been about us or her or, advertising a $100 million verdict, although there's nothing wrong with that. Say if you go try a case, you get a $100 million verdict, you advertise that as much as you can to help other people. But having that client first mentality, that understanding sometimes the $40 million that's offered, and this is hypothetical, the case was, way different value and everything. No, I won't go into that, but understanding that what will be more impactful for that client. Is 70 million, 80 million, 90 million going to be any different than 40 million when someone has more money than they'll ever spend in their entire life, more money than a life care plan? At a certain point, you're just chasing money to chase money.
Well, you're chasing ego.
Ego, that's exactly right. And you know what? I've seen that a lot in our profession. It's disappointing to me. And I will tell you, Sean, I don't know if this has happened to you. There's times I have to check myself. I'll get so emotionally involved and angry at the position the other side's taking and so mad at the lawyers that I just want to go beat the snot out of them. And I'm just like, I'm going to trial. And I have to stop and think, hang on, Charla, you're going to have other cases. This is your client's only case.
I'm fortunate to be surrounded by more level-headed people in my firm. My firm, they basically tell the defense, like, listen, if you don't settle now, it's gonna go on the file's going on his desk.
Yeah, it's not going to be
pretty. You got to deal with him, and you know how he is. But yeah, no, I agree. I think getting big verdicts and not collecting is really, really, really bad for us as plaintiff lawyers. So if you're just getting big verdicts to get big verdicts and you're not collecting the money,
what are you accomplishing?
Well, you're feeding tort reform.
Exactly. Yeah, that's exactly
bad
right.
Bad case law.
Yeah, oftentimes you can create bad case law. I've seen lawyers get a whole bunch of 9-figure verdicts and never collect more than a few $1,000,000 on all of them. You don't want to do that. I'm all about getting big verdicts. Listen, we try cases to get the fair value. And if the fair value happens to be a big number, it's a big number. But I want to make sure I have a plan for how am I going to collect that money in the end. Because if there's no plan and there's no realistic way to collect, what have you done?
That is so true. Well, I had heard about you a lot, but this is the first time I ever got to meet you personally. And just from this little time that we have been talking before the podcast started and during the podcast, you might try to hide it sometimes, but I think you're a man of deep conviction and want to do the right thing and do the right thing for the right reasons. I'm going to ask you a loaded question.
All right.
What do you want your legacy to be?
Oh, man. I try not to think about that at all. I think what I want to be known as is a great father to my kids and a philanthropist. I think those are the things that are important because those are things that will benefit the community moving forward. The legal stuff, I don't really even think about any of none of that matters much legacy-wise. I think, being a teacher, being a giver, probably, giving back is important. So all of that kind of ties into that philanthropy aspect of my
I
life.
got to tell you this. I'm not bragging on myself, but when I've got tears in my eyes, but when I asked you that question, I thought it's going to involve his family. It's going to involve giving back. I mean, you're just that kind of person. We're lucky to have you in our profession. Thank you for going across the country and teaching lawyers how to do better for their clients. It is very, very much appreciated.
Well, thank you for having me on your show. It was a pleasure meeting you. I've heard a lot about you over the years, and it's always weird hearing so much about somebody and, not ever meeting them.
Yeah.
But here I am in Dallas, and Caleb picked me up this morning from the hotel, and beautiful studio, and this was fun.
And you got to meet our four-legged restraining orders, Lucy and Loretta.
Lucy and Loretta were just lovely today. They were great.
I knew Sean was a great guy when Lucy and Loretta went up to him immediately and started licking his hand when he put it out, because they're usually ferocious when people come in.
That's true.
And look how quiet.
Yeah, Loretta.
She loves it. She's learning about big data today.
Yeah.
All right. Well, thank you so much.
Thank you, Sean.
Thanks for having me.
I think you can tell, and we at Aldous Law here, we actually kind of like each other, and we absolutely love what we do. And we work a lot of our cases up from the get-go, but we're brought in on cases a lot. We try cases all across the nation. If you have a case that you're interested in talking to us about, we'd love to hear from you. We've tried everything from trucking, workplace injuries, explosions and burn cases, dram shops, rideshare sexual assaults, birth injury, your personal injury cases. If you need a partner to help you with your case, please call us. We can be contacted at alduslaw.com. We'd love to hear from you.
You've been listening to More Likely Than Not, where the Aldous Law team turns small margins into massive victories. Love what you heard? Don't miss an episode. Subscribe now, leave a review, or share this with a fellow trial warrior. Remember, we're all just 0.01% away from tipping the scales. Produced and powered by LawPods.